Good day, Crime Talk aficionados. It is Thursday, and we have another great episode for you. First on the docket, an expert from the Kohberger case says there's a way to solve the Savannah Guthrie's mother's disappearance. New evidence in the brutal murder and dismemberment of 14-year-old Celeste Rivas Hernandez. The defense challenges the BAC evidence in the fatal car crash involving the Guthrie brothers. A former private equity CEO, gets sentenced for his assault at an In-N-Out burger on a teen. And Thieves live streamed the crime scene and, didn't turn out so well for them. We've got this day in legal history. We've got a legal quote from Abraham Lincoln and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, and make sure you hit that bell for notifications of when we go live or put up new content. So before we get to the docket, let me remind you to go to Crime Talk Prep. Listen, in today's uncertain times, being prepared brings lasting peace of mind. Now, My Patriot Supply, which is trusted by millions of American families, offers the ultimate solution with their 3-month emergency food supply kit. Now, this premium kit delivers over 2,000 calories per day for 90 days through 22 nutritious meal varieties, free of artificial ingredients or preservatives. And guess what? It is all made here in the United States, and it arrives in a durable, stackable bucket and is engineered to remain fresh for up to 25 years. Now, listen, exclusive for our subscribers, our viewers, you can receive $100 off when you order today at crimetalkprep.com. Visit crimetalkprep.com now to secure your family's long-term food security. That is crimetalkprep.com. All right, ladies and gentlemen, before we get to today's docket, I've got some sad news. Yes, but what can I do? But I have some sad news to report. Now, don't feel too sad for me because, it's life. Tragedies happen and you have to move on from those things. But let me show you this. Here's a video of Crime Talk 1 doing a flyby. Yep, that's the last time that we had Crime Talk 1. It is now gone. It'll officially close tomorrow, and it'll be in the hands of a new happy owner. It was a great airplane. Not going to lie, there were some issues that I ran in with a certain shop, but let's just say there's a non-disclosure agreement, so I can't discuss their name, but let's just say it got a little ugly there for a while, but I think I prevailed because let's just say they're the ones that reduced their prices, not me. So we'll just leave it at that. Anyway, one could say owning a private jet could be one of the worst financial decisions one could ever make. There's definitely an argument to be made for that. But on the same token, if poor financial decisions were to be made, it should be made with a private jet. All right. I hate commercial airline travel, and hopefully we won't have to endure that too long. I know it's a tragedy, but sometimes, when somebody makes you an offer you can't refuse, you have to go with it and try to step up maybe to something just a little bit bigger, faster, that goes a little farther. We'll have to wait and see. I will keep you informed of any future poor financial decisions that I'm going to make. All right. If it involves jets and wings, we'll just put it that way. All right. Isn't that a cool video? I mean, seriously, let's play that video again. Just, God, that is so cool. Anyway, Crime Talk 1. Well, we'll see if we got to get a new Crime Talk 1. We'll keep you updated. All right, let's go ahead and open the record for Thursday, February 26, 2026. And guess what? One of the experts in the Kohberger case says he may be able to find Nancy Guthrie, or at least he thinks he can use the technology for it. So, federal investigators performed an extensive final evidence sweep at the Tucson residence of Nancy Guthrie on Wednesday, more than 3 weeks after the 84-year-old mother of Today Show co-host Savannah Guthrie was abducted from her home. Now, the operation signals that the on-site phase of the inquiry at the property may have concluded, even as no suspects have been identified. But forensic expert Heather Barnett, who contributed to the successful investigation of the University of Idaho student murders involving Brian Kohberger, indicated that the perpetrator's possible attempts to erase digital traces could actually assist authorities. She says that the loudest evidence can be the lack of evidence. Now, that's what she said in an interview. She noted that Kohberger created detectable bookends around the crime by deactivating his device immediately before and reactivating his phone shortly afterwards, allowing investigators to establish timelines through cell phone tower pings, proximity data, and obviously movement patterns. Now, Barnhart explains that similar extreme measures such as disabling cellular service, Wi-Fi, or the device entirely do not always eliminate all traces. Now, preparatory reconnaissance or post-incident reactivation could still generate useful signals, and investigators remain hopeful that any oversight by the abductor will, possibly emerge. So just a quick recap. Nancy Guthrie was last seen following a family dinner on January 31st of this year, and police believe that she was taken from her home, her single-story $1 million home in the Catalina Foothills Estates in the early hours of February 1st. And on Tuesday, Savannah Guthrie released an emotional video message marking the 24th day since her mother's disappearance. And in that video, Guthrie announced a family reward of up to $1 million for information leading to Nancy Guthrie's safe recovery or the location of her remains. The family is also donating $500,000 to the National Center for Missing and Exploited Children, also known as NCMEC, and Guthrie expressed continued hope for the miraculous homecoming while candidly acknowledging the possibility that her mother may no longer be alive, and she urged anyone with knowledge to come forward immediately. Now, some sources have indicated that Savannah Guthrie plans to return to New York City this weekend to resume her duties as co-host of the Today Show. She has remained in Arizona with family members since the abduction, but the family is preparing for the possibility that the search may extend for years while prioritizing normalcy for her husband, Michael Feldman, and their 2 young children. Now, the FBI is relocating the majority of its personnel assigned to the case from Tucson to its larger office in Phoenix, although a limited team will continue operations locally. A parking ban has been enacted in the surrounding neighborhood effective today to protect public safety and reduce disruptions caused by media and online streamers. Now, the doorbell camera footage released by police show a masked individual appearing armed and carrying a backpack at the front door around the time of the abduction. Now, reports suggest that the same person may have visited the residence on at least one prior occasion, as indicated by images showing the backpack absent, suggesting possible surveillance and premeditation, obviously. Police have requested neighborhood security recordings dating back as far as January 1st. Now, as you also may recall, multiple ransom demands have been received, including one seeking $6 million in cryptocurrency, whose deadline passed without proof of life. DNA recovered from a glove matching the suspect's apparent attire and from traces inside the home has not matched any national databases, leading investigators to pursue advanced genetic genealogy techniques. Now, this case continues as a joint effort between the Pima County Sheriff's Department and the FBI amid reported coordination challenges, and officials have not ruled out the involvement of an accomplice and maintain that the abduction appears targeted. Well, the family and law enforcement continue to appeal for public assistance, emphasizing that even the most minor detail could prove decisive in resolving this high-profile case and providing answers to the Guthrie's loved ones. And we'll hope that turns out. Obviously, the ransom route didn't exactly turn out what people thought it would be. Made no sense. And no one provided any proof of life, which would more than likely mean that they did not have contact with Nancy Guthrie. Unfortunately, this case is going cold rather quickly. It's basically been cold for the last several weeks. But, obviously our thoughts go out to the Guthrie family so that they can have some sort of closure. Now, it would be great if it was the return of Nancy Guthrie, but if that doesn't return, certainly the family would like closure. And it would be great, obviously, if we could arrest the individual or individuals responsible for the home invasion and kidnapping of Nancy Guthrie. Next, new evidence in the brutal murder and dismemberment of 14-year-old Celeste Rivas. That's right. And the suspect, well, they're looking at that David guy that spells his name with a 4. So in a significant development that sheds new light on one of Los Angeles' most disturbing unsolved cases, well, newly unsealed court records confirms that recording artist David Burke, known professionally as David, that's D4VD, has been designated the principal target of the Los Angeles County Grand Jury investigating the murder and dismemberment of 14-year-old Celeste Rivas Hernandez. Now, the documents filed in support of out-of-state subpoenas served on Burke's family members in Texas detail the gruesome discovery of the teenager's remains and underscores the central role police attribute to the 20-year-old singer. Now remember, no charges have been filed against Burke or any other individual as of this date, and the grand jury proceedings obviously remain confidential until and if there is an indictment returned. So what do we know so far? Now, according to the filings, Rivas Hernandez's body was located on September 8th of 2025 after a tow yard manager alerted police to a strong odor of decomposition emanating from the Tesla sedan that had been impounded days earlier. The vehicle, coincidentally, was registered to Mr. Burke. Upon obtaining a search warrant, detectives opened the front trunk and observed a black cadaver bag covered in insects and emanating a pronounced smell of decay. Inside the first bag were the victim's severely decomposed head and torso. A second black bag beneath it contained her dismembered arms and legs. The condition of the remains indicated prolonged exposure, consistent with law enforcement sources' earlier assessment that the teenager may have died in the spring of 2025, more than a year after she was last seen alive in April of 2024. So what's the deal with the family subpoenas and the legal battle going on in Texas? So prosecutors have sought to compel testimony from Burke's parents, DeWad and Colleen Burke, and his brother Caleb, all residents of Texas. The family challenged the subpoenas in a Texas court, arguing that the materials provided failed to demonstrate how their testimony would be material and necessary to this investigation in regards to their son. And then on February 2nd, a Texas judge rejected those challenges and ordered the witnesses to appear in Los Angeles during the week of February 9th. Now, it remains unknown whether the family members ultimately testified, as grand jury proceedings are obviously conducted in secret. So what do we know thus far? So law enforcement sources previously indicated that Burke has not cooperated with detectives from the Los Angeles Police Department, and they've executed a search warrant at the Hollywood Hills residence associated with the singer, and they removed multiple bags and items of potential things of evidentiary value. The residence is located near the street where the Tesla was sighted and later impounded. Now, in a related development last month, one of Burke's acquaintances, streamer Neil Langston, was arrested after failing to appear before the same grand jury as a witness. That's right, you can be held in contempt for not appearing on a subpoena. Then we also have the Los Angeles County Department of Medical Examiner that previously sealed public details of the case in November of 2025, citing the active investigation, and at that time, the official cause of death had not been determined. So what's going on? The court records had remained under seal during the secret grand jury phase until Burke's families contested the subpoena, prompting their partial release through the Texas proceedings. Now, private investigator Steve Fisher made portions of this newly public file available on social media earlier this week, prompting renewed public attention. And police continue to treat the case as a homicide investigation involving possible multiple participants in both the death and the subsequent disposal of the victims' bodies. Now, detectives have not released any additional information on potential motives or any other names as it relates to persons of interest. So the emergence of these documents is marks the most detailed public disclosure to date regarding the physical evidence and the direction of the probe. Now, as the grand jury works proceeds, further developments, including possible indictments, are anticipated hopefully in the coming weeks. So we will have to wait and see. Clearly, It doesn't take a rocket scientist to figure we probably should talk to Mr. Burke and his friends, right? It's his car. What do we say all the time, ladies and gentlemen? There are no coincidences when it comes to criminal law. Let's see. Your girlfriend, underage, missing, found in your car, in the trunk of your Tesla, decomposing, dismembered. You refuse to talk. Certainly you have a right to remain silent and you're given the presumption of innocence. But there's a lot of coincidences there, wouldn't you think, ladies and gentlemen? I mean, certainly there could be a completely plausible explanation. Perhaps Mr. Burke was out of town. Maybe somebody did something terrible and tried to frame Mr. Burke. I guess these are possibilities that the prosecution will have to try to make sure that, they're not going to use as a possible defense. But usually when there's a situation like this and all the coincidental points point to one particular person, you have to be able to prove it. Not just, we talked about this before, it's not just what you think, not what you believe. It only matters what you prove, what you know took place. Next on the docket, the defense in the tragic case involving the death of NHL star Johnny Gaudreau and his brother Matthew has introduced some new expert analysis challenging the prosecution's blood alcohol level, evidence potentially complicating the proceedings against the accused driver. So in a recent court hearing in Salem County Superior Court, New Jersey, attorneys representing Sean Higgins, the 45-year-old resident charged in connection with the August 29th of 2024 incident that claimed the life of Johnny Gaudreau and his brother Matthew, asserted that revised testing indicates that Higgins' BAC was below the state's legal limit of 0.08. Now, the brothers, both experienced hockey players and family men, were cycling single file along the shoulder of a road in Oldham's Township when Higgins' vehicle struck them. The incident occurred as the siblings were in town for their sister's wedding the following day. Now, Higgins reportedly admitted to consuming 5 or 6 drinks that day, pulled over approximately a quarter mile from the scene, and allegedly failed field sobriety tests. Initial toxicology results presented by prosecutors indicated a BAC of 0.087, exceeding the legal threshold, and supporting charges that include first-degree aggravated manslaughter, reckless vehicular homicide, and leaving the scene of a fatal accident and tampering with physical evidence. Being convicted on all counts could result in a sentence of up to 70 years in prison. Now, during the hearing, which was a virtual hearing before Judge Michael Silvano, defense counsel Richard Killenberger argued that the original test analyzed plasma rather than the whole blood. Now, according to the defense retained expert, adjusting for this distinction yields a BAC of 0.075%. And in New Jersey, the per se intoxication standard under the statute is based on the whole blood alcohol concentration of 0.008 or higher. Now, this adjustment is relevant because hospital or certain lab analysis sometimes measure plasma or serum, which can produce higher readings than whole blood due to differences in density and water content. Now, courts in New Jersey have recognized the need for proper conversion factors when plasma results are involved to align with statutory whole blood standards. And under the New Jersey law, specifically New Jersey statute 2C 11-5 governing reckless vehicular homicide, also known as death by auto, proof of driving while intoxicated in violation of that statute creates an inference of recklessness. However, the statute allows for a finding of recklessness based on other evidence, even absent a per se BAC violation. Now, prosecutors may still pursue homicide-related charges by demonstrating impaired or reckless operation through factors such as admissions of drinking, observed behavior, field sobriety performances, or the manner of driving. And Higgins reportedly passed a slower vehicle before striking the cyclist. Now, the distinction between plasma and the whole blood results could undermine reliance on the initial BAC figure for per se intoxication inferences but does not automatically eliminate the possibility of proving impairment or recklessness through circumstantial evidence. Now, the prosecutor requested time to review the defense experts' findings with the state's experts and investigators, and the judge indicated that if prosecutors concede the revised BAC calculation, they may seek a new grand jury indictment. The judge also encouraged plea negotiations, noting a prior prosecutorial offer of 35 years and a defense counter proposal. Higgins' earlier motion to reduce or dismiss charges based on claims that the victim's own alcohol consumption contributed to the crash was previously denied. The matter is scheduled for further proceedings on April 14th, and when the prosecutors are expected to address the BAC dispute and any progress on plea negotiations. Obviously, this development arises shortly after the 2026 Winter Olympics, where the men's hockey team, honoring Goudreau's expected participation, secured a gold medal victory over Canada. Team members celebrated with a tribute, including displays of jerseys bearing Goudreau's name and number, which is 13, and Goudreau's family attended the related events. And obviously, they brought the children out for the team photo as well. So that's going to be an interesting one. Now, the defense score a little bit of a shot across the bow. Yeah. Does it mean that the driver is going to be getting off scot-free? No. I've seen extreme indifference, reckless homicide cases go to trial without a BAC, even if it's 0.075. And even if they calculate the numbers, there's a lot of extrapolation that they can do to maybe determine that at the time of the driving, it was higher. Remember, alcohol goes into the body, and it's like a bell-shaped curve. It goes up and then it comes down. So the question is was the BAC rising or was it decreasing at the time of the accident? Those are things that the state's experts will, I'm sure, enlighten the prosecutor on in this particular case. Next, a former private equity CEO, well, he gets sentenced for assaulting a teen. That's right. A 57-year-old former chief executive of a private equity firm has received a sentence of probation following his guilty plea in connection with the assault of a 15-year-old boy during an altercation at an In-N-Out Burger in northern Colorado. So Lucas Calishier pled guilty on February 23rd to second-degree attempted assault involving strangulation, a Class 5 felony, under the plea agreement reached in the district court up in Fort Collins. So the agreement resulted in the dismissal of the more serious charges, including second-degree assault by strangulation and child abuse. So what do we know that actually happened here? We brought you this story when it first happened. So the court imposed 30 months of supervised probation, so 2.5 years. Conditions of the sentence require Calishier to complete an anger management evaluation and any recommended treatment by the probation officer, submit a formal written apology to the victim, and perform 120 hours of community service and pay $207.86 in restitution. So what took place? This incident occurred shortly after 1 a.m. on August 4th in 2024 at the Loveland In-N-Out location. Now, according to the police reports, the 15-year-old and his companions were playfully splashing water among themselves when a small amount accidentally struck an adult woman seated nearby. The teenager immediately approached the woman to offer an apology for the mishap. Police stated that Calishier then placed both hands around the front and back of the boy's neck, pulled him towards the table, and threw him backwards onto the floor. Now, Calishier and the accompanying woman left the restaurant before law enforcement arrived. He later surrendered to police after an arrest warrant was issued. Obviously, the case had a lot of attention after surveillance footage of the confrontation circulated on the news and on social media. Anyway, Mr. Calishier, a Loveland resident who previously served as the chief executive of a private equity firm, now faces strict compliance requirements. Failure to adhere to the terms of probation could result in a sentence on the underlying felony, which could conclude up to 3 years in the Colorado Department of Corrections. Now, this resolution addressed the case that involved elements, obviously, of an assault, strangulation, and child-related charges in the context of this little setting in a fast food restaurant. Anyway, what can you say, ladies and gentlemen? I got a lot of things to say about it. I get it. Boys will be boys, and they'll be doing stupid things like splashing water at 1 a.m., in a restaurant. It's the equivalent of a bunch of boys and kids that age playing grab ass. Keep your hands to yourself. How about you not splash water on anybody? Quit being stupid. Now, did Mr. Calisher overreact? Yes, absolutely. And now he has a felony conviction, ladies and gentlemen, for something stupid that happened at 1 a.m. Who knows if there was alcohol or anything else involved, but he clearly overreacted, and now he has a felony conviction that will follow him for the rest of his days. Hopefully he made lots of money, and maybe he doesn't need a job ever again, but you think he's going to have a job in private equity with a felony conviction on his record? Probably not. Something to think about, ladies and gentlemen. When something stupid happens, take that deep breath, let it go. The kid apologized, for God's sakes. Were they stupid? Were they, should have been behaving better? Absolutely. But did they deserve to be choked out? Probably not. Next, what do we say all the time, ladies and gentlemen? Don't live stream the crime scene. That's right. 4 suspects have been convicted on multiple charges following the theft of approximately $2 million in jewelry after prosecutors obtained video recordings of the individuals made on their own criminal conduct. The group gained access to 5-star jewelry and repair by drilling a hole through the adjoining wall of the neighboring coffee shop. And although the suspects attempted to disable surveillance by spray painting the store's security cameras, and one individual crawled low across the floor to evade motion detectors, they simultaneously documented the burglary on their own personal recording devices. And guess what? Footage captured inside the store shows one suspect gesturing with a peace sign towards the camera, while another pans across the substantial quantity of stolen jewelry as the looting continued. The same recording reveals the large breach in the wall. A separate clip depicts the group using a crowbar in an effort to open a safe, and 2 additional videos filmed after the suspects returned to a residence showed them counting and sorting the haul of new and heirloom jewelry, which police valued at roughly $2 million. Investigators combined these self-incriminating recordings with security camera footage from the adjacent coffee shop to reconstruct the full sequence of events. And yes, the Ventura County District Attorney's Office presented the evidence, resulting in convictions of all 4 of the individuals with their videos. Now, obviously, suspects' decision to record their criminal activities ultimately provided police with the decisive proof for their convictions. Don't live stream the crime scene, ladies and gentlemen. And, if you're going to go commit crime, and I'm not telling anybody they should, I'm telling you don't do it. But if you do, for God's sakes, don't record it. Idiot. I mean, God, so stupid. And I would tell that to the client. I would tell that to the client as well. Why are you being so stupid? And sometimes you have to be that way to clients. For example, yesterday I had a client. He, let's say, hadn't joined us in a while, and he got picked up. And he has this bright red hair that he had dyed. And we're talking bright red hair. And I told him before he comes to court, to resolve his case, and since we're going to go to immediate sentencing, you may want to shave off that bright red hair. And, he professed how much he loved his hair and how much he liked his hair. And I said, well, you have to kind of know your audience. You have to be able to read the room. And this very conservative judge probably wouldn't be impressed with his bright red hair, particularly when we're trying to say that you're going to be a responsible individual. But some people just can't read the room. And guess what? He showed up with his bright red hair, and everybody winced a little bit. Even the DA was like, really? You look like the Joker, for goodness sakes. Anyway, I don't know. Does anybody ever listen to their attorney? I'm starting to think, no, they do not. Next, how about this day in legal history? On February 26, 1869, Congress passed a joint resolution proposing the 15th Amendment to the United States Constitution and submitted it to the states for ratification. Upon its ratification on February 3rd, 1870, the amendment prohibited the United States or any state from denying or abridging the right to vote on account of race, color, or previous condition of servitude. Obviously, that Reconstruction-era measure represented a foundational advancement in civil and voting rights, fundamentally reshaping the constitutional framework for suffrage following the Civil War. How about February 26, 1919? President Woodrow Wilson signed into law an act of Congress that officially established the Grand Canyon National Park in Arizona. The legislation protected one of the nation's most iconic natural wonders as a federal preserve, obviously a significant milestone in public land management and environmental conservation. And hey, if you've never been to the Grand Canyon, it's worth going. It's pretty spectacular. I always think of, there was a Fred Flintstone cartoon years ago, and they were standing there, Fred and Barney, and it was like a little creek running through, and it had a little sign that said Grand Canyon. And they looked at it and they said, well, it's not much today, but they say it's going to be pretty spectacular someday, because it was just this little stream running through. And next, on February 26, 1962, the United States Supreme Court issued a unanimous per curiam opinion in Bailey v. Patterson, holding that no state may require racial segregation of passengers in interstate or intrastate public transportation facilities. And obviously that reaffirmed prior precedents declaring segregation unconstitutional. Now, some people may say, Scott, what the hell is the difference between per curiam decision and just a regular decision? Well, it is a Latin phrase that literally translates to by the court or through the court. And so in legal practice, particularly in appellate courts such as the Supreme Court, a per curiam opinion is a judicial decision issued collectively in the name of the entire court or the panel of judges, rather than being authored by a particular judge or attributed to any particular justice or judge. As a result, these opinions are unsigned, but it is basically saying the court agrees that this is what the law should be. Next, how about a quote, our legal quote of the day, coming from Abraham Lincoln. And I was having a conversation the other day about the high cost of litigation, whether it's civil or criminal. And I've told you, oftentimes litigation is a war of attrition. Who can go the longest before having to file for bankruptcy or have to take a plea bargain in a criminal case because they simply don't have the resources to continue? This is nothing new. In fact, Abraham Lincoln had a quote regarding the cost of litigation years before, nearly 25 years before he was elected as the 16th president of the United States. And in his notes for a law lecture written back on July 1st, 1850, then not President Lincoln said, quote, "Discourage litigation. Persuade your neighbors to compromise whenever you can. Point out to them how the nominal winner is often a real loser in fees, expenses, and waste of time. As a peacemaker, the lawyer has a superior opportunity of being a good man. There will still be business enough," end quote. Anyway, so that quote directly explains why litigation obviously is expensive. Even the party that technically wins in court frequently incurs substantial attorney's fees, court costs, discovery fees, expert witness fees, and obviously the lost productivity that exceeds the value actually recovered. So remember that when you have a basically hollow victory in which the winner emerges financially worse off than if the matter had been resolved through compromise. And obviously this perspective remains, relevant in contemporary legal practices. It's interesting that it continues way back then, 1850. But what do we keep telling you, ladies and gentlemen? We always act like this is something new. These types of issues have been going on for thousands of years since there have been lawyers. People don't like paying lawyers. It's expensive. It's time consuming. There's no guarantees of winning. It's a tough business to be in, but it's also tough to have to make those decisions of whether to litigate or not. And then finally today, our dumb criminal of the day. A sanitation worker making his rounds in Ohio got an unexpected surprise when he opened a trash can and found a man hiding inside the trash can. Well, take a look at this dash cam video posted by the Huber Heights Police Department on their Facebook page that shows the worker rolling the bin towards the garbage truck, lifting the lid and quickly staggering back before pointing towards the container as the officers pull up. Police said the man had fled on foot after a traffic stop earlier on Monday, and then officers briefly lost sight of him and set up a perimeter in the area. Obviously, the video shows the man climbing out of the bin and taking off running as the officers chase. Now, during the pursuit, the man lost his shoe, and guess what? He was ultimately taken into custody without injury. His name wasn't released, but unidentified Ohio man hiding in a trash dumpster can. You are our dumb criminal of the day. Congratulations, you made it. All right, ladies and gentlemen, that's all we have for you for today's show on Thursday. We'll see you tomorrow. And remember, the Constitution matters.